Hi guys, this is a run through of an MBE question in constitutional law. For this question, the first method I will be using will be looking at the call of the question first, going through the answer choices, and then going back up to the fact pattern. Although, as you will see from the uniqueness of this question, and this is the reason why I'm picking it to show you how for some what I would consider really unique questions that you don't need to actually read the fact pattern. So the first method, going through the call of the question, then looking at the answer choices, you should feel very confident that you have picked the correct answer choice without having to read the fact pattern. So that's what we'll do first. And then second, we'll go through the call of the question, run through the answer choices, and then go back up to the fact pattern to make sure that we are not missing anything. On the actual exam itself, you would want to pick the correct answer choice, then go make a notation about it that you didn't actually read the fact pattern, although you are confident what the answer should be. But then if you have time at the end, you would want to come back and make sure you double check the fact pattern to see that you haven't missed anything. Then the last method we'll go through will be just starting from the top and going all the way down. But this is a unique MBE question. They have some of those. And if you get really good at doing these types of questions without having to read the fact pattern, but still be able to know what the correct answer is confidently, they are very, very nice questions to have on the exam. So let's go ahead and start with going through the call of the question, then picking the answer choices, or going through the answer choice and picking the correct answer, then or eliminating as many of the answer choices as you can, and then going back up to the fact pattern if we need to. But as I will show you for this special question, you will unlikely need to actually look at the fact pattern if you have studied well. The call of the question is, can the injured parties recover the full balance of their blue state court judgment from the state of red in the enforcement proceeding they filed in a court of red? When I see blue state, red state, state A, state B, those types of questions, you would be thinking of constitutional law. So that would be my inclination, is to think we're in constitutional law subjects. So I would make a note of that. As soon as I read that, my thinking would be con law. Then at this point, though, if you have studied the conflict of law and this area of law, you would be thinking, because the call of the question is, can the injured parties recover the full balance of their blue state court judgment from the red state or from the state of red in the enforcement proceeding they file in a court of red? That is triggering to me the full faith and credit provision. And this is a fairly straightforward rule that my answer immediately would be yes, they can, because every state needs to give full faith and credit for the laws of other states. And in this case, a judgment, it sounds like they're trying to enforce a judgment from blue state in red state. And the answer should very clearly be yes. So this is one of those types of questions that when you see it, you should be able to pick a correct answer, or at least have that answer in your mind that yes, because of the full faith and credit clause, look to see if there is an answer choice that matches up to that thinking. If there is, then you should be confident that that's the correct answer choice. Double check the other answer choices to see that you're not missing anything, and then move on. And you can use your time for other questions without having to read the fact pattern. You should feel confident because, as I said, this is a pretty straightforward rule. But do make a notation that you skipped the fact pattern. Find some sort of asterisk or a star or a dot of sort. Make sure that you jot down you didn't read the fact pattern. So once you've gone through all of the questions, you would go back to double check the fact pattern in case you've missed anything, just to verify that you haven't missed anything in the fact pattern. So our thinking should be, yes, they should enforce this judgment because of the full faith and credit clause. Answer choice A says yes, because the final judgment of blue court is entitled to full faith and credit in the courts of red. You should be thrilled to see this answer choice, and it matches up just exactly like the answer choice that or it matches up exactly like what we had said we were thinking about. So I would say, okay, this is a pretty good answer choice. Answer choice B, well, first you would be favoring the yeses. Answer choice B, yes, because a limitation on damage awards against red for tortious actions of its agents would violate the Equal Protection Clause of the 14th Amendment. Equal protection, this doesn't have anything to do with equal protection, likely, because we're talking about a judgment. We're talking about court judgment. And as far as tort damage awards for tortious actions, that really doesn't have anything to do with equal protection clause. Having these two things inside of an answer sentence, it's a red flag that probably is not the best answer choice, because you don't associate torts with equal protection clause, and you don't associate damage awards with equal protection clause, because there really is no fundamental rights involved. So I would still be favoring answer choice A, especially since it really matches up with your full faith and credit thinking as you finish the answer or the call of the question. Now for C, the answer choice no, because the 10th Amendment preserves the right of a state to have its courts enforce the state's public policy limiting its tortious or its tort liability. Again, public policy and tort liability, then they're bringing in the 10th Amendment, because the 10th Amendment preserves the right of a state to have its courts enforce the state's public policy limiting its tort liability. I'm not sure that that is an accurate portrayal of the 10th Amendment, because it's not an unwaivable right for them to decide cases involving tort liability. And so especially since you see this answer choice matches up so well, I would be not really happy with this answer choice. The last answer choice, no, because the employees of red were negligent, and therefore their actions were not authorized by the state of red. You could eliminate that, because this is analyzing negligence. We're talking about judgment. They've already resolved the negligence case and have received a judgment. So that's a foregone conclusion. We don't need to go back and look at that action. So I would say you should confidently pick the answer choice A, and not have to look at the fact pattern. But as I said, put a star or some sort of a marking to indicate that you picked an answer without reading the fact pattern. And when you have finished all of the questions, go back to double check that you haven't missed anything. Now we will run through this constitutional law question, doing the call of the question, looking at the answer choices, then going up to look at the fact pattern. Right. The call of the question is, can the injured persons recover the full balance of their blue state court judgment from the state of red in the enforcement proceeding they filed in a court of red? When I see blue state, red state, that's an indication that it is a constitutional law question to me. So my thinking would be constitutional law question. And then when it's saying enforcement proceedings they filed in the court of red, we're looking at enforcing a judgment, it looks like. And that to me is an indication of the full faith and credit clause, which means it is which means I should be thinking, or you guys should be thinking, that the answer should be yes, because every state needs to give full faith and credit for the laws of other states, including judgments in this case. So I would be favoring the yes answer choices. Right. Answer choice A says yes, because the final judgment of the blue court is entitled to full faith and credit of the courts of red. This matches up very well to our thinking, and I am liking that answer choice a lot. B says yes, because a limitation on damage awards against red for tortious actions of its agents would violate the Equal Protection Clause of the 14th Amendment. No, there is no constitutional violation if you set limits on damage awards. States do it all the time. So you can cross out this answer choice because that is a wrong statement of the law. Then C, no, because the 10th Amendment preserves the right of a state to have its courts enforce the state's public policy limiting its torts liability. It sounds a little bit similar to answer choice B, but it has a little bit, if you will, a twist to the what it's saying, which is because the 10th Amendment preserves the right of a state to have its courts enforce the state's policy limiting its tort liability. They, in general, the 10th Amendment doesn't give any unwaivable right to have their courts decide cases involving tort liability of the government. So in this case, since we have the answer choice in A, you really should not be tempted to pick answer choice C. You may not be able to eliminate it readily as you can for answer choice B, but leave it there. Still, answer choice A is looking really good. The last answer choice D, no, because the employees of red were negligent and therefore their actions were not authorized by the state of red. This answer choice is highlighting the tort of negligence. When you see that there's a judgment already, you're not looking at liability and you're not analyzing negligence anymore. So you should be able to eliminate this answer choice easily. And as far as A and C, if you go up to the fact pattern, you can look at what the fact pattern says, keeping answer choice A and C in mind to see which one you would think fits better at this point, I would still be favoring answer choice A. The fact pattern goes, the state of red sent 3 of its employees to a city located in the state of blue to consult with a chemistry laboratory there about matters of state business. This is confirming that we're probably in constitutional law. And so it continues on, while in the course of their employment, the 3 employees of red negligently released into local blue waterways some of the chemical samples they have received from the laboratory in blue. So this is the negligence here, and we're able to eliminate it when we go to the next fact pattern, next paragraph. Persons in blue injured by the release of the chemicals sue the 3 red state employees in the state of red in blue state courts for the damages they suffered. After a trial in which all of the defendants admitted jurisdiction of the blue state court and fully participated, plaintiffs receive a judgment against all of the defendants for $5 million, which became final. So they really have, as we suspected, resolve the tort itself, the negligence, and we know that there's a judgment, so we don't need to worry about the negligence aspect of it, which confirms that eliminating answer choice D is correct. Subsequently, plaintiffs sought to enforce their blue state judgment by commencing a proper proceeding in an appropriate court in red. And this is the key. Again, this is triggering the full faith and credit clause, and it's confirming to us that they're testing us on the full faith and credit. In that enforcement proceeding, the state of red argued, as it had done unsuccessfully in the earlier action in blue state court, that its liability is limited by a law of red to $100,000 in any tort case. Because the 3 individual employees of red are able to pay only $50,000 of the judgment, the only way the injured parties can fully satisfy their blue state court judgment is from the funds of the state of red. That is bringing in the answer choice D, answer choice D, that is, it's bringing in the state of red, which is triggering the 10th Amendment analysis. And the answer choice in C says no, because the 10th Amendment preserves the right of a state to have its courts enforce the state's public policy limiting its tort liability. That may be the case, but it's not an unwaivable right to have their own courts decide cases involving tort liability of the government. So the 10th Amendment really is not a good argument to hide behind for them to step in to pick up the 50 or pick up and fill in the gap of the judgment. So answer choice A is the best answer choice here. Now we will go through the fact pattern first, then go to the call of the question, then the answer choices. The fact pattern goes, the state of red sent 3 of its employees to a city located in the state of blue to consult with a chemical laboratory there about matters of state business. With this fact pattern, I'm seeing state of red and then state of blue. That is an indication that it's probably a constitutional law question. So if we keep going, it says, while in the course of their employment, the 3 employees of red negligently, now we're highlighting that there's a negligence. So could it potentially be a negligence question? We don't know for sure at this point. And it continues. So that second sentence goes, while in the course of their employment, there's also, we should make a note in the course of their employment that highlights the negligence, vicarious liability, which is in negligence. In the course of their employment, the 3 employees of red negligently released into local blue waterways some of the chemical samples they have had. Some of the chemical samples they had received from the laboratory in blue. Persons in blue injured by the release of the chemical sue the 3 red state employees in the state of red and the state of red in blue state courts for the damages they suffered. After a trial in which all of the defendants admitted jurisdiction of the blue state court and fully participated, plaintiffs received a judgment against all of the defendants for $5 million, which became final. At this point, we see that they received the judgment, and we should now think, well, we're not having to analyze negligence anymore because the court has already decided that they got a judgment, that the plaintiffs won the case. Subsequently, plaintiffs sought to enforce their blue state court judgment by commencing a proper proceeding in an appropriate court in red. Now they're suing in red. They are bringing the judgment that they received to enforce it in the state of red. In that enforcement proceeding, the state of red argued, as it had done unsuccessfully in the earlier action in blue state court, that its liability is limited by a law of red to $100,000 in any tort case. Because the 3 individual employees of red are able to pay only $50,000 of the judgment, the only way the injured parties can fully satisfy their blue state court judgment is from the funds of the state of red. So they are wanting to enforce the judgment from blue state in red state. This triggers the full faith and credit clause. And in general, each state needs to give full faith and credit to the laws of other states. At this point, I'm thinking that the injured persons, the plaintiffs, would be the winner, let's say. But let's look at the call of the question. Can the injured persons recover the full balance of their blue state judgment from the state of red in the enforcement proceeding they filed in a court of red? This, to me, confirms that we are looking at the full faith and credit analysis. And at this point, I would be biased to thinking that, yes, it's likely that they will be able to enforce the judgment in the state of red. You look at the 2 yes answer choices. A says yes, because the final judgment of the blue court is entitled to full faith and credit in the courts of red. That really matches up, and that looks like a really good answer choice. But go through the other answer choices to confirm that there are no other good answer choices. B says yes, because a limitation on damage awards against Red for tortious actions of its agents would violate the Equal Protection Clause of the 14th Amendment. There is no constitutional violation if a state wants to limit its tort damage recovery. So states do it all the time. This is not a good reflection of our understanding of the law. So you should be able to eliminate answer choice B, and especially since you have a really good answer choice in A, since it matches up with your thinking while going through the fact pattern and the call of the question. Answer choice C says no, because the 10th Amendment preserves the right of a state to have its courts enforce the state's public policy limiting its tort liability. This answer choice is forcing you to go back to think about this part of the fact pattern here, where it says because the 3 individual employees of Red are unable to pay, they want the state to step in to cover the difference that the individuals, the employees essentially, are not able to cover. And there is no right under the there's really, the 10th Amendment doesn't give the states a right to have their courts decide cases involving tort liability. And so since this case has already been decided in blue state and they have a judgment already, we're only concerned about the judgment. We're not concerned about the rights of their the state preserving their right to have their court enforce tort liability limits. So it's not really an answer choice that I would favor over answer choice A. Then the last answer choice, D, says no, because the employees of Red were negligent and therefore the actions were not authorized by the state of Red. We really are not needing to analyze the liability of those agents, those individual agents themselves. This again is highlighting the analysis for negligence and the vicarious liability idea, which says that the principal is liable for its agent if there is a agency relationship, and there's, in this case, they're trying to argue that these individuals are liable on their own and the state is not liable on their behalf because their actions were not authorized by the Red state. None of that is part of the analysis here. It's a foregone conclusion. Now we have a judgment. The question is, can the Red state be forced to enforce the judgment of blue state? And yes, under the full faith and credit clause. Okay. So A would be the best answer choice here because none of the other ones really match up perfectly to our analysis.